All right. I believe we're on to the next item on the agenda, which is the Board of Governors questions, comments, and discussion. Any members of the Board of Governors have any questions, comments, or have any discussion they'd like to raise at this time? I'm going to volunteer one that I got on the phone from one of our governors, and I don't know if he's still on there. Oh, there he is. Governor Peterson, would you like to share what you shared with me on the phone, or do you want me to share? *6 to unmute if you're on a phone, if you're on the phone. Okay. He
there you go. I think I unmuted. I was having trouble unmuting. Thank you.
There you go.
Yeah, the question was, and I don't know the answer, but I know it's been discussed. And before I ask the question, I guess I want to indicate clearly that I'm very pro section. At least where I sit right now, I think it's very important that the sections remain part of the Bar Association. But the question I have though is, if the bar was to be bifurcated, or if the sections were to be carved off, would they still be bound by GR 12 or not? I've heard answers yes and no from various people, so it's just more of a point of clarification for me. Thank you.
Anybody want to take a thought at that? All right.
I'm just saying I agree with Hunter. I don't think they're different than any other member of the bar. So nothing that's sanctioned specifically by the Bar Association.
Our general counsel's got something, and then I believe our past president's got something, and then Alex Stevens. So do it in that order.
Yeah. So GR 12 is addressed to the Bar Association. It says the purposes of the bar. And then if you're talking about the limitation language in 12.2C2, it talks specifically about what the Bar Association cannot do. So if they're not part of the Bar Association, then it would be hard to explain how that rule wouldn't apply. I'm sure that there could be lots and lots of gray questions, like what happens if they create a bunch of content and then, for the bar to use, right? That's where we might have issues. And then I think GR 12 is separate from the First Amendment analysis, right? Keller is not the same as GR 12, but again, if they are in a separate organization that doesn't have compelled fees, then that drops away as well, potentially. So, I think it does drop away. So yeah, looking at all those things, trying to figure out, what does it mean if they're separate? How separate is separate? If does separation require zero ties? I don't know the answer to those types of questions, but I'm hoping that you're all gonna, look at all of it and not sort of feel caught in any kind of a box, so that you consider all potential answers to the question, and maybe even especially ones that have not been suggested anywhere else yet.
And along those same lines, I'm thinking that the comments that Executive Director Nevitt and Governor Boyd and I heard yesterday were kind of geared toward that issue, figuring that if the sections were not a part of the Board of Governors, not part of the WSBA, then they would be free to do whatever they want and be outside the confines of GR 12.2. I think that was the sentiment. It was very interesting to hear today from the sections that there's value to being a part of the WSBA and their support. And while there may be some tensions once in a while, overall, from at least those four sections, the benefits outweigh the cons, and they strongly prefer to be a part of the WSBA. And I think that's wonderful. Remembering what Mr. Fay said about whether the sections could even survive outside of the WSBA is interesting. I wonder whether if the U.S. Supreme Court decides to bifurcate all bars, whether the WSBA survives without these sections. I think that would be an interesting thing to think about, because, and again, another thing that Mr. Fay said was most people who see the Bar Association are benefiting and see themselves as a part of the sections. So I think we should all think about that as we move forward, and also as part of our analysis of Plan B. So part of this is what should we be, but part of this analysis is also what happens if the Supreme Court comes in and says you have to bifurcate. So Plan B might be a good discussion time for that same analysis. Great to hear from 4 sections. I want to encourage other sections to come to us. We, as President Tollefson said, we have built into our schedule 2 full days of public comments. I think one of them's in July, coming up in July, and one maybe a little sooner. In any event, I encourage other sections who may be reviewing this online, live, or on tape to, maybe consider coming in and sharing your views too. And the same thing with regard to the boards. We heard from a few boards today, and some of them not having a position at this present time. But maybe as we get further into the schedules and the discussion topics, things might pop up that might influence them to have a position. And at those 2 days, it would be appropriate to hear from those folks as well on whether their positions are changing, solidifying, or maybe there's issues that are coming to mind that we're not thinking about now. So I'd encourage people to continue to think about coming back to us and talking with us further.
Governor Stevens, I'm sorry. You're next up.
Thank you. So I guess the first thing I wanted to say, and when I heard from Nancy, and of course it's the sections that brought me to WSBA as an active member, as opposed to somebody who pays their dues and does their CLEs and gets on with life. I think Kyle will recall this, that, and a few of you who went to the last Western States in Kauai, I said in a full session, I am an association guy. I want the association. But I also am looking at, I'm somebody who is in resistance, but not in denial. And so I don't know that I'm ready. In fact, I'm not sure I'm ready for the word bifurcation. There may be other words, and there may be other concepts that we use. I would not so much want a full and complete split as opposed to something else that keeps us connected, but perhaps those functions that are outside, or as Julie would call them, continuously not germane, would be where one would volunteer to join that entity. And so that may be something to be said. But I am strongly in the view that I don't want us to wait. I've said this many times, but I'm gonna say it again. I would like to have a plan B if we have to do something. I don't want to wait until now we have to do something, and now we've got to scramble to figure out what that something is. I think we really, so I think it's valuable and useful. And down the road, we will be looking at various proposals. I don't know that he's on right now, but I'm still intrigued with what Tom McBride is thinking about, and it's not time yet to put that on the table, I guess. But that's something I'd be interested in. Julie, and I was in my car on my phone in the car, so I didn't know how to operate it except to hear what was going on. So I did have a question for Julie, and we were talking about purposes, and I don't know if purposes or analyses, if our mission statement has anything relevant to say about what our activities are. And I only asked that question because, we have three purposes, at least our three parts of our mission, the members, the public, and to champion justice. And so I'm going to keep pushing, Julie. I want to understand in that area of championing justice. So I'm not talking about the administration of justice now. I'm talking about our mission that says championing justice. And, at a later time, I'd like to have that conversation, because if we're going down this posture that we can't speak on those things, then, what's the point of having those words? Are those words just there to make us feel good? Are those words just there to show that generally we care, but we won't do anything as an association? And I don't mean to get snarky, but I'm just kind of saying, if we have that as one of our prongs for why we exist, what's the point? But maybe an alternative way to structure our organization. So I'm not going to say association. I'm going to say our organization may be in that category. And like I said, I'm going to be very interested. And Hunter, I'm going to be interested in not you giving the thumbnail sketch, but actually laying out how you think it ought to work. But I'll be looking at alternatives as a plan B. I am not looking at necessarily saying, well, we're just going to adopt that alternative, but I'd like to have that at the ready if things don't go well for us. Thank you.
Thank you, Governor Stevens. Governor Peterson, followed by Governor Pertzer.
Yeah, no, thank you, President Tolleson. So I think this question is mainly for General Counsel Shanklin, but if anybody else has an answer, please pipe up. So I guess my general understanding about this issue, and like I said, I just want to make sure I understand the answer. This doesn't indicate, like I said, I'm very pro sections, but if the bar were to bifurcate and then the sections were to do their own 501Cs and have their own individual names, it seems pretty clear to me that in that situation, GR 12.2 would not apply. But if the bar were to bifurcate and we still had kind of a, you can still elect to be a part of a section kind of the way we do currently, and those sections, even though it was voluntary, would still be called WSBA, the WSBA Corporate Counsel section. It seems to me like in that situation, even though it's part of the voluntary part of the bar, and it's a voluntary election to be part of the WSBA Corporate Counsel section, it seems to me like in that situation, the section would still be bound by GR 12.2. Is that correct?
So I'm a little bit confused by your question, because it's a voluntary election to be part of a section now, but the bylaws say, that sections are bar entities created by the bar to help the bar do what it's doing. And, I think there's been a lot of discussion here today that, it's kind of all maybe integrated is a bad word to use, but you know, it seems integrated. The sections are doing work and they're being assisted by staff, and I don't know that you can literally, you know, untwine and separate it, but I'm sure there's a question in there, and I'm sure that I didn't understand it.
Okay, so let me simplify it. If we bifurcate the bar and the sections end up being in the voluntary side of the bar, and they're called, like, you know, the WISBA corporate counsel section, the WISBA real estate section, would they in that point in time still be governed by GR 12.2?
Ah, okay. I think I see. So even if they're a separate entity, somehow we allow them to use our name. That seems confusing. And yeah, that's a good question. And I'd really have to think about that. I don't know why we would, well, never mind. If they are a separate entity, literally the wording of GR 12 is that the Bar Association, you know, in general, the Bar Association strives to, the purposes of the State Bar Association are. So if they're not the State Bar Association, then I think this particular court rule doesn't apply to them. I guess there could be a different court rule that could apply to them, you know, and that they're not going to be funded using compelled license fees, I would assume, if they're a separate organization. You know, so then all the stuff we were talking about wouldn't apply to them. But so I did want to say, like, the word bifurcation, I don't know exactly what that means. And I mean, obviously bifurcate means to divide something. Yes, but you know, the devil's in the details there, because what goes where? I'm unaware of anybody really thinking about just the sections. So the sections are engaged in a lot of different activities, as Kevin's presentation showed. Some of those have expressive content and some don't. So at least all this case law stuff we've been talking about in germane versus non-germane, it's all focused on activities with expressive content. That includes things like bar publications, and potentially CLEs and legislative activity. And, you know, and it's not just the sections that engage in that work. So I'm not understanding this conversation to just simply be about sections. And maybe it is today because they presented today, but I think some of the court created boards also engage in expressive activities. So I'm not 100% sure I understand exactly what you mean by bifurcate. And I am hoping that we will get information from other bar associations, because some of the structures that we have seen, you know, it's not just simply regulatory sections on, or regulatory functions on one side and sections on another. Like that's just not what the dividing line is.
I'm just going to ask a question as a member. We talk about bifurcating the bar, and if the bar goes into the state. I was just curious about another potential plan C, I guess I'd call it. All of the admission to practice, discipline, MCLE, etc., if that went out of WISBA and was administered by the Supreme Court Clerk's Office or something like that, and WISBA, or some other name, under some other name, became a totally voluntary bar association and had 29 sections in this totally voluntary bar association, where you didn't have to join, it's voluntary, but those who join are going to pay presumably bar dues as opposed to in addition to their license fees. Now, what my question is, what would be the legal limitations on what that new voluntary bar with its sections would be allowed to do?
Yeah. Well,
I assume there are states that have voluntary bar associations that are doing something, so that may be a template for us to talk about.
right. And, you know, if you read the cases, that's one of the things they sort of say is, well, listen, there are like 20 states that operate, at least on the surface, similarly to what you've said. I think, you know, we don't have enough detail to be knowing exactly what we're talking about, like exactly which functions are in voluntary bar and exactly which ones are done by the court. But yeah, that is one of the models that exists. And that is one of the arguments that the plaintiffs in these challenge cases are making to say, yeah, so show me that integrated bar is the least restrictive means, you know, because 20 other states are doing it a way that is less restrictive of First Association or First Amendment rights. And so, you know, how is it that you could meet the required constitutional test? So yeah, that is definitely a place to spend some time thinking about, you know, but yeah, exactly what would go in a voluntary bar and exactly what, if anything, the court would be willing to take over. That might be a conversation to have with the court.
Okay, I have some other hands up. Got Governor Pertzer followed by Governor Stevens.
Thank you. I was going to kind of echo what Kim just said, and then also what Governor Stevens said. You know, we have, I think our marching orders is to, you know, decide what potentially might be the structure of the bar in years to come, based on the current, you know, status of these lawsuits. But I guess one other question I'm thinking about is asking is that, you know, we're here to provide, I think, or produce some options, potential options to the Supremes. And one of those options might simply be that it should no longer be an integrated bar, and that the regulatory or the part that where you have to be a member of is just certainly for the regulatory purposes. And I'm just wondering if we were to make a proposal like that, the Supreme Court says we're going to do that. We don't want to wait for a decision to come down where it says we have to make a change. We want to preempt that aspect of it, and so that there's just no question that we're no longer integrated. It's simply a mandatory bar for regulatory purposes. And so I just, you know, I don't know that I understand it to be simply a situation where we like what we have now, but we can see something else later on that might come about. It might be something where we focus on, you know, a couple of different options and give the pros and cons of both of those options, or whatever number of options we have, because ultimately the Supreme Court's going to make a decision, or they may ask for more information. But I don't see it as just that is a set structure. I think we have to be mindful that they might want to see some options here that avoid some problems down the line if there is some type of a decision that occurs where we have to make a change. It might be easier to make the easiest change and make the recommendation for the easiest change so that we can transition quickly. But just my thoughts on that, and just kind of curious of other people's opinions on that.
Anything else, Governor Pertzer?
No, thank you.
Governor Stevens.
Yeah, well, one of the things when I was listening, especially to Ms. Hawkins, but others, that I wanted to clarify, which was specifically we wanted to hear from the sections today, to actually hear from them as it relates to their point of view regarding our structure. And I think we heard loud and clear, and that certainly resonates with me. But one of the things as we were having the conversation, I was also realizing, which was if we were to somehow or another change our structure to have some sort of dividing line between the what mandatory fees went to and what voluntary fees went to. In any case, I believe that would have to be something that hopefully WISBA as we know it would actually shepherd through how that happens, as opposed to, because as I was hearing some of the conversations, it wouldn't be sort of, we've now cut you loose, good luck. And, and I don't think that's what anybody on the board was saying. I certainly wasn't saying that and don't see that. And there are a lot of details to work out and work through in any case, because otherwise, I actually believe that the larger sections may be able to do that on their own. What their own looks like is a whole other thing as well. So I would hope there wouldn't be a spinoff where there would be 3 or 4 different organizations of sections. I think it's more important to think about a way in which, if we were to do this at all, how we do it in a way that captures all of them and whatever, in fact, Julie and Tara, one of the things I'd like to know is, just given our entity matrix, if we were to talk about the regulatory functions, and then I wonder if the mandatory functions are one and the same, but supported by fees. And then, what happens if you have those other functions? I'm still looking at some sort of unitary administration and not just 2 separate and independent entities. So, those are some of the devilish details that I'm sure we have to get into down the path if we even decide to do a plan B.
Thank you, Governor Stevens. Anybody else have their hand up? Any other questions, comments, or discussion from governors